SwayamPrabha. Digital India. Educated India.
Good afternoon. This is Professor Anupam Jha. This is lecture number 12, and today we will be dealing with the major legal systems of the world. Why we need to understand about the major legal systems of the world? Because this world has different legal systems. You go to one country, you go to another country, you will find different legal system. Maybe that because of the impact of colonialism, there might have been a possibility that one or two legal systems may be same, and maybe that 3 or 4 or maybe 10, 20 legal systems may be similar. Now, in that case, what should we do? How can we understand the legal systems of the whole world? Now, this is the thing that we want to understand. And today we will learn about those major legal systems of the world. Students, if you look at the whole world is too big, and likewise the legal systems are also many. Now, in that case, we have to just think that how many legal systems might be there in the world. As we all know that there are more than 200 countries in the whole world. Now, in that case, whether there are more than 200 legal systems in the whole world. Now, this is the thing that we should also try to ponder over. But the answer is very simple, that the legal systems of the world, those are not as many as 200 or more than 200. Why? Because of the fact that the colonialism had impacted the whole world, and during the height of colonialism in the 18th and 19th and also some part of 20th centuries, the colonizers, they had also supplanted the legal system, their own legal system in the colonies, and therefore the legal system which they had, they took it to the colonies. And therefore, because in those times at the height of colonialism, what happened that only you could have counted upon your fingers that these are the countries which have the rule over the whole world, and therefore the legal systems in the whole world, that can be divided into only 3 or 4 categories. And therefore, today we will try to learn about those major legal systems. We are not trying to understand about the domestic legal system right now. Today we will be understanding about the major legal systems of the whole world. So, we will be trying to understand that what is the difference between the domestic legal system and the major legal system. As I told you, that major legal systems mean that a legal system which might be also having its presence not in one country, but also in many other countries. But the domestic legal system is only limited to the country itself. So, in this case, we are trying to not understand right now about the domestic legal system, but we are trying to understand about the major legal systems. Now, how many major legal systems are there? That we will also try to understand, and then what are the things, what are the basic traits, how to distinguish between the different major legal systems of the world. All these things we will try to understand today. So, how many major legal systems in the whole world are there? We can say that there are 3 or 4 or 5, maximum 5 major legal systems of the whole world. And those are, the first is the common law family of legal systems. The second is the civil law family of legal systems. The third is socialist legal systems, and the fourth is customary or tribal systems. The fifth may be religion or region practice based system, and the last may be called hybrid or mixed systems. So, these are the different, we can classify, we can try to understand the major legal systems in 5 or 6 categories, but first of all we will try to look at the first major legal system of the whole world, which is the common law family of the legal system. Now, common law family, as the name suggests, what kind of law, what kind of legal system does this family represent? Does it mean that the law is common for all the people, or does it mean differently? So, this is the first question. What is the meaning of common law? You see what happened, that this is the legal system which originated in Great Britain, and you all know that Great Britain had the rule over a large part of the different continents of the whole world. So, the UK, which had this legal system in which it was basically trying to maintain law and order amongst all the people, to maintain peace and harmony amongst all the people, and therefore this law developed as a result of what we say public law, how to maintain the public harmony, how to maintain the public peace and order, and on that basis, understanding the need to have such kind of public law, this public law, what we call common law, this started to develop, and the role was in this, the major role to maintain the peace and harmony amongst the members of the society, that was of the courts, the system, the institutions which were established by the kingdoms of that time, and that was called the courts. So, courts were the wing of the state, and the courts had the power to deal with such situations that they can issue some order by which the peace and harmony, someone can be arrested also. So, this was a kind of branch of the public law, and therefore, it was called common law. So, this is the common law. So, common law family of legal systems. Why we call it family? Because there might be different legal systems which are there, like in a family there are many members. Likewise, this is a family of legal systems. So, there may be little bit of variations when we go into the nitty-gritties of the legal system, but as far as the whole system is concerned, as far as the overall system is concerned, what we find, that we find the same trait or the same characteristic in the legal system. Then we have also to understand something about the civil law system. What is the civil law system? Does it have another name also? Yes, it has another name, and that is called Romano-Germanic family of legal systems. We may call it the civil law family of legal systems, or we can call it Romano-Germanic family of legal systems. Now, what is this kind legal system? Why is it called the civil law family of legal system? Because this legal system was mainly developing out of the need to have a law for the individual members of the society. Each member, how they will come into contact with each other by way of marriage or by way of kinship, or if they want to have business relationship, how they will come into contact, whether there is a need of agreement or not. So, this was basically the relationship governing methodology amongst the people. So, how the people individuals, they will interact with others, that is very important, and out of that need, the civil law family. The civil law means that which is not pertaining to the society as a whole. So, civil law means it is a based upon the individual's needs, individual's relations, and therefore, the civil law family of legal systems that emerged out of that need. Now, where did this emerge? Did this also emerge in UK, United Kingdom or Great Britain? The answer is no. This system originated in the continental part of Europe. Continental part is which part of Europe? It is that part of Europe which is the whole continent of Europe minus England. So, in that portion, what we say that the civil law family of legal systems that came up. Now, you will wonder that why it came up there. Now, it has a long tradition, or you might say there has a kind of history behind it. And what is that history? Because of the fact that there was in the even before Christ, there was a time of what we say the Roman Empire. And in the Roman Empire, during the time of Roman Empire, what happened that the emperors, as we all know, that the Roman emperors were also very powerful, and they had tried to expand their territories into different parts of the whole world, including one of the Roman emperors, he had also come to India. Now, so considering all these things, you will think, did they not do anything to expand their laws, legal systems? The answer is yes. In that time, what happened? One of the emperors of the Roman Empire, Justinian, so he had done a great thing, and what you will find that this Justinian had tried to codify the laws which were spread at that time. So, this word codification became very important. So, it was a state led exercise. Before that, there may have been different attempts to codify, but not at the level of a state. It was at the level of individuals. So, this was for the first time that at the level of a state, at the level of emperor, whole exercise of codification that started. You might wonder that what is this word? Is this not a jargon? Codification is not a jargon. The answer is yes. If we just understand that codification means that you just codify something into one place, but this is not the meaning of the word codification. Codification means that the laws which might have been spread or which might have been scattered in any part of the whole world, or maybe that suppose if we are talking in the context of the kingdom, then in the whole kingdom, the territory of the kingdom, if the rules are spread or scattered, then codification means that first of all the codifier or the group of people, they will try to collect the scattered laws at one place. But then the question may come that what will happen to those rules which might have been there, which might have been assembled at one place maybe 100 years back, and then suppose if it is now found, what is its relevance? Now, the answer lies in the fact that when the codification will start, the people who are there, the people who have tried to collect the different rules, they will look at the quality. They will see that whether the rules are going to make the progress in the existing society now or not. If they will find that these rules need to be changed, if they will find that these rules need to be amended a little bit, keeping into consideration that this society has to be a different kind of society, our goal is different. Now, in that sense, the people who are there to codify the laws, what they will do, that they will not only assemble the scattered rules, but they will also try to give it a modern shape. And once it is done, thereafter what will happen, that the arrangement of the rules, this is called the new technique, the legislation, what we call legislation. So, the codification in those times meant that the different rules were put together at one place and they were arranged systematically. So, this was a science, codification became a science, codification meant a scheme of things, codification meant a certain kind of system there. So, that thing was there and that was started during the times of the Roman Emperor Justinian. So, Justinian, when he had done it, when he completed this exercise in the centuries before the Christ, now he was successful. That was very important. That was a landmark, that he was successful in codifying the laws which were scattered all over the country. So, when he was successful, you might be wondering that why was it not carried out further, why it did not continue further, because you might be knowing, if you have a sense of history, you might be knowing that after that, Alexander's time and thereafter, there was a kind of different era in the whole world, and the whole world was witnessing wars and conflicts and wars between different religions came up. So, in that situation, what happened, that there was no ethics, there was no rule during the war, and so many universities were burned, etc. Many literary works, those were lost, and that happened with the legal codified rules. So, in that case, what happened, that there was a vacuum for the next 1000 years, and thereafter, you see, after the 1000 years, again you might have heard that in Western Europe the Renaissance that started, and when the Renaissance started, thereafter Germany was the cradle of the growth of this kind of interest in the legal works of the past. So, the universities in Germany, they took a lot of interest in studying the past, particularly the Justinian Code, and you see that after that, what happened, that Napoleon Bonaparte also came to power, and when Napoleon Bonaparte he came to power, and he had established long territory, he had a long base of his kingdom, French Empire, that was empire, and he also tried to codify the law, and you know what, that he was also successful, and you might have heard that a Napoleon Code, and we can call it Code Napoleon. So, Napoleonic Code was also a very important development during the time of Napoleon Bonaparte. So, this was also an example of codification. So, what we say, that in civil law, what will happen, that the laws will be codified, and in the modern times, if we continue this thing, then the codification, like the Justinian Code, like the Code Napoleon, which later on what happened, that this trend of codification, that was considered to be more useful than having a system where there was no codified law, because in that system you will have to first of all come to the court and then say that Judge Sahab, this is the law, and then you will have to prove that whether this is the law, who made the law, who gave the law, all these things you will have to say. But if there is a codified law, which is the state made law, then there is no such problem. Then there is no such problem that, okay, can you prove the law? So, this is about the Roman civil law system, Romano-Germanic, or we can call it the civil law family of legal systems. What are the essential features of the Romano-Germanic or the civil law family of legal systems? The first thing that I told you was that the, what we say, codification, the codified work, the codified law, that was the first thing, and this is the basic characteristic of the civil law family of legal system. And second thing is that the civil law family, the judges of the civil law family, they will not be trained in law, meaning thereby that in the civil law family of legal system, the judges, they do not have to first of all become advocate, and thereafter they, after long practice, they will become eligible to become a judge. Now, this is not the fact in the civil law family of legal system. There may be the possibility that a judge may be there in the court who has not studied technically the whole kind of certificate course or degree course in law, and even then the person can become a judge of the court. Now, this is a very unique feature of the civil law family of legal system, where the scope of appointment of judges is not based upon the whole training, the specified training or the specific training in law. And there is a possibility that, suppose if I have not studied law, I am just an engineer and I have got a job after my BTech, and maybe that I have 20 years of experience in a particular field of engineering. So, maybe that I will be appointed as a judge in the matter which had come to the court, and in which there was an engineering matter and there was a dispute regarding the engineering or some kind of scientific things. So, in that case, maybe that I can be invited to the court to become a judge. So, there is no hard and fast system in the civil law family that you have to be a LLB holder. Like in our country, we have to have LLB first and then we can become even an advocate. But there in the civil law family, maybe that a person who has not read law, who has just who is just an architect, or maybe that a person who is a chartered accountant but has a lot of experience, in that case there is a possibility that the chartered accountant can also be brought in the court as a judge to adjudicate the dispute. So, this is a very unique feature of the Romano-Germanic or the civil law family of legal systems. Now, again we will move back to the common law family of legal system, and we will find that in the common law family of legal system, the whole procedure is also different in the courts. If we come to the civil law family of legal systems, then the procedure in the court will also be different. So, what is that difference that we will also try to understand. Now, as we see that in the common law, what we will see that the judges, they will be listening to the parties, and then the parties, they will be represented in the court by the advocates. And what will advocates do? Advocates will try to convince the judge that, lordship or Judge Sahab, this is the matter, this is the evidence, and I do not accept the other party's contention, and therefore the judge would be convinced by the one party that this is how the judgment should be given. And on that basis, judge decides the case, and maybe that if the court is the higher court or the highest court, then there is a possibility that the judgments that will become judicial precedent, and that judicial precedent is also a technical thing, that suppose if this is a precedent, then whether this precedent will be followed in other cases. Now, in the common law family of legal systems, you will find that the precedents are to be followed, and this is binding. So, the common law family has developed in that way. In the common law family, it is not that suppose if the higher court has given a judgment, then the lower court will not be bound by that judgment. So, this is a point which must be understood very clearly, that the courts in the common law family, they have more powers in this sense also, that the judgments, if the court is the higher court or the superior or the highest court or the apex court, in that case what may happen that it will be binding, it will be called judicial precedent, and this will be binding on the lower courts and also in the similar cases in future. But if we talk about the civil law family or the Romano-Germanic family of legal systems, you will find that this is not the case. There the judgments of the higher court, that is not technically binding upon the lower courts. So, the lower courts have greater freedom to apply the law. And what is the law? Law is laid down in legislation. In the civil law family of legal system, in the Romano-Germanic family of legal systems, you will find that judges, they are not bound by following the judicial precedents, rather they are much more concerned about the codified laws or what we say legislation. So, what is the legislation? What is the law on the point? What law is passed by the state? This will be more important for a judge in the Romano-Germanic or the civil law family of legal systems. But in the common law family of legal systems, what will happen that the judge, even if there is no legislation, because you might be having a sense of history, you will find that the Britishers, they had not codified their laws for a very long time. They were ruling over the whole world, but they had not codified the laws. And you might have heard that our penal laws, for example, Indian Penal Code, that was codified in the year 1860. But if you look at Britain, in Britain there was no such codified penal work. If we again come back to India, we had the codified law on contract, but back in UK there was no such codified work. So, the Britishers, they tried to experiment with legislation in their colonies rather than first of all experimenting on themselves. So, this was a different kind of way of the Britishers, and that was also not much appreciated, but now we can say that our country was even first compared to the UK to have legislation in that sense. But what I was trying to tell you, that in the common law family of legal systems, what happens that the judges, they rely upon the judgments even if there is no legislation. And when the Britishers, when they had expanded their colonies and territories into different parts of the whole world, what they were doing, that they were not much concerned about codification of law, because that involved a lot of expenditure. So, what they did, that they established the courts and they empowered the courts to exercise such powers by which their judgments would be binding upon the lower courts. So, they developed a doctrine of what we say judicial precedent, stare decisis, that the decision of the higher court and they have to be standing on their judgments, mean that they should not deviate from their judgment in the similar cases what they might have already declared. So, this is the feature of the common law family of legal system. But in the civil law family of legal system, the judge will first of all try to look at the legislation or the codified laws made by the state, and because they are not bound by the judicial precedents, therefore, they will least bothered to look at the judicial precedents. So, in the civil law family, this is the kind of difference as compared to the common law. And from there a different thing emerges, is about, which is again related to the procedure, that in the common law family what will happen, that the parties, they will be considered as adversaries to each other. So, one party, there are two parties in the court, one party and the other party, one party will consider other party as adversary and the other party will consider the first party as adversary. So, this will be a procedure which is called adversarial procedure, adversarial system, in which the one party will try tooth and nail to establish his or her case in the court, and likewise the other party will further try to convince the court that no, he or she is right and not the other party. So, in the adversarial system, which is the feature of the common law family of legal systems, the judges, they have a different role. They are not actively participating in the matters of the whole courtroom drama. What they will do, that they will be listening to the kind of litigations between the parties, how the advocates, they are trying to substantiate their cases, and on the basis of the decisions of the court, judges will have to listen, and thereafter what they will do, that they will ask some questions if they have certain doubts relating to the points which are canvassed by the litigators. The judge will try to understand the point, and thereafter the judge neutrally will say that okay, this is the time for judgment, and then passing the judgment or ordering something. So, this is the kind of system in the common law family, and which is called adversarial system, where the judges play a passive role, not an active role in the proceedings of the court. But when you go to the civil law family of legal systems or the Romano-Germanic family of legal systems, you will find that there is no such adversarial system. It is not that what the parties, two parties will say, that will be only understood by the judge. Maybe that judge will try to do something more, and that power of the judge, by which the judge has the capacity to say something and to look at the truth of the matter, that is called the whole, this procedure is called inquisitorial system. So, adversarial was the feature of the common law, and this is the feature of the civil law. Which feature? It is called inquisitorial system. Inquisitorial system means that the judge and all the other parties, they have one interest. The interest is that they will try to go to find out the truth of the whole matter, because this is called inquiry. It is about inquiry. Everyone will inquire what is the truth in the matter, including the judge. So, judge will have also a role in the whole process, and sometimes judge may say that no, I am not satisfied with the evidence because the truth is still not seen, and therefore what he will say, or he will suggest that you see that I am going to collect evidence now, or he will order a fresh collection of evidence because he was not satisfied, the judge was not satisfied with the evidence which are submitted by the different parties. So, in that case judge will play an active role. He will not simply be a neutral third party, he will not simply be a passive spectator to the whole thing, but he will have an active role. He can say, he can ask questions with the objective that the truth may be found, and not only that, if he is still unsatisfied, then he or she can go to the scene of the crime, he or she can go to look at the whole thing afresh and finally come out with the new evidence, and then on that basis, if he is satisfied, he will give the verdict. So, this is called inquisitorial system, and this is the feature of the civil law family of legal systems, Romano-Germanic family of legal systems. So, you will find that in the common law family, the system was called adversarial, and in the civil law family of legal system, the system is called inquisitorial system. And this is also very important to understand. Once you understand, then you will find that in the common law family, the judges, who are the judges? The judges must have a specific training in law and in the legal procedure, and therefore you will find that in the common law family of legal systems, who are the judges? The judges have a particular degree in law, like LLB degree in law, or in US you will find that they have the JD degree. So once you have the degree in law, then only you can go to practice in the court. And you see that how will you have degree? Like to pass the whole LLB exam in most of the universities, semester systems are followed, and in the semester system 4 or 5 papers are there. You will have to pass 4 or 5 papers, you will have to write to pass the paper. So it means that you have to undergo through a rigorous process of understanding the law and then writing about the laws, and then you become an advocate. You have developed the power of analysis and then argumentation, and on that basis you have developed the capacity to convince the judge. After long years of practice, you can become a judge, and then when you write the judgment, what kind of quality will be there? The quality of judgment will be very high. And what you see, if you have any time to look at the judgment of the courts, you will find that the judgments of the courts of the common law family are longer, they are not short. In the civil law family of legal system, you will find that the judgments of the courts are shorter. Why? Because if you remember what I said, that the judges in the civil law family, they are coming from various backgrounds. They are not essentially trained in the legal education. However, in the common law family, they are trained in legal education. They are also having training in advocacy, and thereafter they become the judge. So therefore, the writing, they have the writing skill. The judgments are long and they are technical also. Maybe that they will include the precedents, the judicial precedents are also included in the judgments. So this will be the kind of judgment in the common law family, but this will not be there in the civil law family of legal systems. And you will find that in the civil law family, the judgments are shorter and to the point. Maybe that there will be no mention of any judgment, but of course there will be the mention of relevant legislation in the judgment of the civil law family of legal systems. As far as the similarities between the common law and civil law family are concerned, you will find that kind of Christian morality, in fact, because all these systems are the Western systems. So of course Christian morality and philosophical teachings of the whole time, which gave rise to individualism, liberalism and the personal rights. So these are some of the similarities between the common law family of legal system and the civil law family of legal system. But what I told you, that the differences between the common law and the civil law family of legal system, those are very important, because then you can identify clearly that okay, this is the civil law family of legal system and this is not the civil law family of legal system, which is the common law family of legal system. So differences are very important, and I told you that the common law family is based upon judicial precedent rather than on legislation, but in the civil law family of legal system, it is based upon legislation rather than judicial precedent. So this is the kind of difference. And then you will find that the application, as far as the application of common law family is concerned, the common law family, where was it applied? It is also easy to understand once you know a little bit of history, that what were the portions in the whole world that Great Britain had its colonies or the territories. Now, in all those places you will find that there is a spread of the common law family of legal system. For example, our own country was under the rule of Britain. So, our country is a part of the common law family of legal system. Likewise, you go to US, in US majority of the portions of US, they are having the common law family, because the whole colonization in the US east coast, that was by the Britishers. So, Britishers had started colonizing the east coast of the US, and those people, they were instrumental in getting the independence from the Great Britain way back in the 18th century. So, you will find that in US also common law family system is there. But as far as the civil law family, the application of this system is concerned, you will find again that who were the countries like Spain, like Holland, and the Dutch, and all these countries. Germany was also an empire, France was also an empire. These all countries, they had their territories all over the world, including in Africa. So, you will find that many parts of the world, for example, you take the example of some portion of Sri Lanka, which is very close to our country, that was influenced by the French people also. So, they had an influence from the civil law family of legal system. Some of the portion of India also was under these countries, like France was having control. So, we will see when we will come on to the Indian legal system, we will see that how our own country was influenced by those legal systems. But right now what I am saying, that the application of these legal systems, those spread all over the world by two ways. One was by way of use of force, that because they had conquested over the territory, and therefore they were entitled to extend their rule, including the laws, to that territory. And second was that sometimes the local people, they also thought that no, this system is encouraging individualism, this system is encouraging liberty, which was lacking in those times. So, there was both things. One was voluntary support for the system, and the other was kind of forceful application of the system. So, in both these ways you will find that the common law and the civil law family, they spread all over the world. If you have understood these basic differences between the common law family and the civil law family of legal systems, we will now move on to the third family of legal systems, which is called socialist family of legal systems. Now, this is a different system. Why? Because the socialist word comes after the word capitalist. So, this whole socialist system of law or legal system means that the system has a focus upon capitalism, that how to erode or how to wash out capitalism. So, this socialist legal system is a legal system in which the legal system will be based upon the objective that the capitalism, what is the meaning of capitalism? In very simple terms, you will find that capitalism means that person who has a capital is having more power than a person who is not having capital. You see, and therefore, everyone is trying to make more capital and more capital. Capital does not mean only money, but capital means many other things like land or any kind of resource like machine or some other kind of different kind of resources, not person, right. But the socialist legal system is not trying to say that everyone should be engaged in increasing the resources or the capital, and it should be based upon, rather it should be more focusing upon equality amongst the people. So, socialist legal system is always trying to have equality amongst the people. So, they may forget liberty, they may forget capitalism, they may forget more money, but what they will do, they will try to have equality amongst all. So, this is the motto of socialist legal system, and therefore, the legal system is made to accommodate that how this equality can be ensured. And for that, what they will do, that they will not be satisfied with any kind of judicial precedent, they will not follow any judicial precedent, and what they will do, that they will be constantly changing their laws, and the laws will also not be, so they will say that laws are what? Laws are static and they maintain status quo. So, what they will do, that they will also try to change the laws very frequently, so that it will be trying to promote equality amongst the people. And therefore, what will happen, that the state will be more inclined not to make laws, rather they will be trying to have policies. So, in the socialist family of legal system, what you will find, that the whole character of the state is kind of revolutionary, that what they will try to maintain equality by way of struggle. So, struggle in the capitalist system is not considered good, but in the socialist legal system, the struggle or the upheaval or the revolution will be considered good for the society, because if it is for a purpose to maintain the equality amongst the people. So, if you find the source of socialist laws, you will find that the source is in the revolutionary work of the legislature, and therefore, the laws which are passed by the legislature, even the courts, they must say that they are having the popular will, and therefore, they will not try to deviate from the laws which are made by the legislature, because that has lot of strength, because they represent the popular wish, the popular will, and therefore, the judges, they will not be empowered to change it. Unlike in the capitalist system, what we call the Western legal system, or we can say that the civil law family of legal systems or the common law family of legal systems, wherein the judges have the power to review the laws made by the state legislature. Now, this is a great power which is vested upon in the judges in the common law or in the civil law family of legal systems. But socialist family of legal system, you will find that the judges are not vested with the power to question the law's authority, the authority of such law which are passed by the legislature, because the judges are subservient to the popular wish or the popular will. So, in that case, socialist family of legal system is different, and you must note that these distinctions in the socialist legal system you must understand. There are other non-Western legal systems, and which we will also see, like we will see the Chinese legal system, and in the Chinese legal system you will find that the legal system is largely based upon the socialist legal system. However, they are trying to change it, and they are also having a combination of the socialist legal system as well as the civil law family of legal system. So, gradually they are also changing it. Likewise, the Black Africa and Malagasy Republic, you will find that these are the communities where the individual sense of individualism is not very much there. So, they are still following the tribal sense and collective. So, you might have heard about African Charter of Human Rights. Now, this is an example that even today in Africa or Malagasy Republic, you will find that this kind of collective sense of doing something, that prevails in Africa. So, African legal system is largely, they will not be very happy if everyone will become individualistic. So, this kind of legal system where everything should be based upon collectivism and group, so that is very relevant in Africa. Likewise, there are another system like the Jewish law. The Jews, you might have heard that Jews were one of the oldest people in the whole world which codified their laws. So, they had also extended their laws into different parts. Wherever the Jews are there, they will have their own system. Likewise, there is a Muslim law, the whole system of how the Prophet Muhammad, how he preached and how that is relevant. So, that is the highest law for the Muslims. And likewise, in Muslim law you will find that the concept of punishment and the concept of law is also different. So, in places where the Islamic rule is there, the legal system may be influenced by the tenets of Islam, and maybe that the legal system will be influenced like that. Likewise, the Hindu law also, wherever Hindus are there, they have their own personal laws, and the legal system should be largely based upon the tenets which they follow and the customary practices which they follow. So, this is also, these are the systems which are based upon the practices of the people which follow a particular way of life. So, whether it be the Hindu law or Jewish or Islamic, you will find that this legal system is also relevant. So, in conclusion, what we will find that one of the fundamental reasons for the differences in approach may be that what is the debate between the proponents and adversaries of the different notions of the legal system. And you will find that the Western people, they will be still trying to say that their own system is very good, and the socialist people, USSR, now there is no USSR, Russian Federation, or the people or territories which are influenced by the Russian Federation and the Chinese legal system. So, there are different people and they will say that their legal system is good, and that should have been like that, that every legal system has unique properties, and therefore, a legal system or the family of legal system that is different from others, but many of them, they have similarities also. But in the Western societies, you will find that there is a large degree of equivalence between justice, positive law and social manners, and that is also percolating down to the different parts of the world. So, in conclusion, what we may say, that in the whole world, the different legal systems which are there, you must try to understand, and there are features by which you can identify a particular major legal system. If you have understood the traits or the characteristics, different characteristics of the different major legal systems of the world, then you will very easily identify that this legal system belongs to which family of legal system. So, once you have understood that, okay, adversarial system, this system is following adversarial system, then you will quickly say that yes, this is a member of the family of common law family. If a system is following inquisitorial, you will quickly say that this is the system which is following the civil law family of legal system. So, once you understand the different major legal systems, it will be easy to understand the domestic legal system. And in the next lecture, maybe that we will try to understand about our own legal system, the domestic legal system, the Indian legal system. I hope you might have understood the whole concept of major legal systems. Thank you.
I am A.K. Sharma and I am professor of sociology at IIT Kanpur. The question I am going to address is what is urbanization? Urbanization is essentially the process of population concentration, which means that if more people start living in a smaller number of places, or if the distribution of population becomes more unequal, like more people living in places like Bombay, Calcutta, Mexico, then we say that the urbanization is taking place. Essentially it means increase in percentage of population living in areas or localities which are defined as urban. Urbanization is a new phenomenon, of course, a post-industrial phenomenon. About 200 years ago, hardly 5% population of the world lived in urban areas, and today more than 50% population of the world is living in urban areas or localities which are classified as urban. You will be happy to know that according to 2011 census of India, in our own country for the first time, increase in the urban population has been greater than the increase in the rural population. Though India is not so urban as the developed countries, and about 31% population of India only is living in urban areas. We can believe that in 10 years, 20 years, 30 years time, India will also be more urban, at least more urban than what it is. It may not be 80%, but certainly it will be 35% or 40%. Now, how is this urban locality defined? Because this definition of locality as urban or rural is crucial to measure level of urbanization. I will give you definition of our own country. In Indian census, an urban locality is defined in two ways. There are statutory towns and there are census towns. All places with municipality, municipal corporation, cantonment or notified town area committees are called urban. This is statutory definition. According to demographic definition, there are three main criteria. If a locality has more than 5,000 people, or 75% of male labor force is engaged in non-agricultural activities, or the density of population is 400 per square kilometer or 1000 per square mile, then we say that the locality may be classified as urban. There are many other additions to this definition. Now we have the concept of urban agglomeration and many other things, but essentially this is how urban population is defined in India. And as I said that urbanization is associated with economic development and industrialization, same is the case with India. About 100 years ago in India only 11% people were living in urban areas, today 31% are living in urban areas, and this is obviously linked with economic development of the country, growth of per capita income and industrialization. I remember that in one 5-year plan it was mentioned that today this urban population can grow by way of natural increase of births minus deaths in the urban areas itself or through rural to urban migration. Today nearly 60% contribution to growth of urban population is due to rural to urban migration, and this is going to increase. This is essentially what urbanization means. Urbanization means growth of population in localities defined as urban in relation to population of localities defined as rural, and I have given you Indian definition. Thank you very much.